inspecting anyone else?
I am not, Your Honor, no.
Neither am I. We're all set.
Okay, good. All right, Shannon, you can put us on the record now.
Okay.
Okay, good afternoon, gentlemen. We're here on the matter of Showerman versus Henry Ford Health System. Could I have each of you state your appearances, please?
Good afternoon, Your Honor. William Harsha, appearing on behalf of the plaintiff, Felicia Showerman.
Good afternoon. This is Daniel Rashert on behalf of Henry Ford Health System.
So, Mr. Rashert, this is your motion. You may go ahead.
Your Honor, this is a premises liability case where a fall occurred when plaintiff was leaving work at Henry Ford Allegiance Hospital at approximately 5 a.m. on January 17, 2019. Defendant filed its summary disposition motion asserting that the claimed hazard resulting in the fall was open and obvious. My assertion is just that. The condition in question, which was ice on the surface of a parking lot, exceeds the standards set forth by the Michigan Supreme Court and the Court of Appeals specific to this topic and the facts of this case. I stress there are no questions of fact. The sole basis of defendant's factual assertions are from the testimony of plaintiff Ms. Showerman. There's no issue of material fact in dispute. Moreover, plaintiff, through her response, failed to set forth any material issues of fact that would defeat a motion pursuant to 2.116C10. The hazard in question was open and obvious based simply on the fact that plaintiff, an individual of ordinary intelligence, actually discovered the hazard and potential risks upon casual inspection. In other words, she noticed and appreciated the surface of this parking lot appeared wet, and then that it was either water or ice. And those are factors that are outlined in numerous cases. And what the case law cites are factors that would alert a reasonable person of the foreseeable danger of slipping on the ice. At the time in question, it was 21 degrees. It was 5 a.m. It was the middle of January. There was snow flurries. That's important. It establishes that there was evidence of black ice in question, and it was visible upon casual inspection before the fall, and there was undoubtedly an indicia of a potentially hazardous condition. This was the test pursuant to the Michigan Supreme Court in Slaughter, and it also was applied in another Supreme Court case about 2 years later, Jansen. Ms. Showerman testified that she appreciated prior to stepping off the sidewalk onto the surface of this parking lot that, quote, there was a possibility that the parking lot could be slippery or icy. She seemed to test with 1 foot while standing on the curb, and she recognized that there was what she thought could be ice. And then applying those factors I mentioned from Slaughter and Jansen, the objective factors, it was 21 degrees, it was snowing, it was wintertime. These are factors to be assessed, these objective wintry conditions as stated in Jansen versus Sajowski Funeral Home. Factors that are present and considered when the Supreme Court essentially overruled the Court of Appeals and reinstated the Wayne County Circuit Court's granting of summary disposition in absolving liability. What sets this case apart, interestingly enough, from some of the cases I attached to my reply to plaintiff's response, was that not only was this open and obvious, but plaintiff actually recognized the hazard. In most of these cases, the plaintiff didn't recognize the hazard until after the fact. And they still, then under those circumstances, they looked at the objective conditions and granted a motion for summary disposition under open and obvious. Ms. Showerman appreciated that this could be ice, this could be slippery, and it goes back to that standard. Indicia of a potentially hazardous condition, that's Slaughter. So based on even the more stringent Slaughter test, this case requires dismissal. On top of that, there's no special aspects that exist that would preclude the application of the open and obvious doctrine, this was not unreasonably dangerous, and it was avoidable, as per Ms. Showerman. There was an alternate route to her car, and I did attach that as an exhibit to my motion, Exhibit D.
So I did note in the response that the plaintiff had indicated that in order to take the alternate route, she would have to access a building that was locked. So I'm a little confused as to what alternate route you're talking about.
Well, Your Honor, I was a bit confused about that as well. So ultimately, there's a passageway that goes through the building, and I believe that's what plaintiff was potentially referencing, excuse me. But the alternate route is the sidewalk around the Anderson building. So that's the green line on the exhibit.
Which exhibit was that? Okay, I've got it.
Exhibit D. They should be colored copies, I hope.
Oh, okay. Hold on.
See that green line? That's the green line. That's the alternate route. The red line is her route.
Oh, okay. So the red, let me get my bearings here. I am familiar with the parking lot.
So the red line is where she exited the building, attempted to cross through the parking lot into her car. The green line is taking the sidewalk to her car. That's the alternate route. And Ms. Showerman acknowledged that that was an available alternate option. And I believe I quoted her testimony.
I see. There's a shortcut through the building, which she couldn't take because the building was locked, but there was nothing preventing her from walking on the sidewalk.
Exactly. And you can see, I think I may have drawn a line there, if I'm not mistaken. Apparently at 5 a.m. that may be locked and she doesn't have a key, but regardless, she can just continue on the sidewalk.
And then I see a blue line.
I threw that in because that was another option that Ms. Showerman testified was an available option, crossing and then walking down the sidewalk and then crossing again. So there were theoretically two available options. I would sort of, focus more on the green line, which was staying on the sidewalk as opposed to cutting through parking lots.
So she appreciated the potential that it could be icy by gingerly stepping off the sidewalk onto the parking lot. It determined, at least in the immediate area where she stepped off, it was not slippery, and then proceeded a few more steps where it was slippery.
That's my understanding. Exactly. So I sort of pictured in my mind, she had one foot on the curb and stepped down with the other foot and then chose to proceed and walk and made it approximately 3 or 4 feet and then slipped.
Okay, thank you. Mr. Harsha?
You're welcome.
Thank you, Your Honor. I'm certainly aware that the court is knowledgeable in this area of the law, not your first hearing of this type. So, and I think both parties briefed the law very well. I do take issue with the fact that this was visible. It was not visible. What the plaintiff testified to was that the parking lot appeared wet. And so she was concerned that perhaps it was icy. She stepped off, did test the surrounding area. It was not slippery, so she proceeded. She also testified this was the safest route to take. The alternate route suggested by defendant, if I understand correctly, is to have her walk in essence around almost 3/4 of the building to get to a sidewalk that takes her to the building. That sidewalk is in essence part of the parking lot. And there's no evidence that that condition was in any other condition than the parking lot where she fell. If you look at that exhibit as well, there isn't a sidewalk immediately on the other side that leads to anywhere. It leads to, I believe, their air conditioning units that are protected by large cement pillars that do not allow you to access there. And I believe there may even be a gate there as well. So again, the plaintiff testified she took the safest route. She's certainly aware of the area and the surroundings. She did take appropriate precautions in encountering this condition. But there is a big difference between having to make a casual observation and conducting an inspection. And under the law, the defendants are required under these circumstances to conduct an inspection. And they certainly had enough time to do that. Obviously, they were aware that people are in this area. It's a gated lot. There are cars. People are crossing through. The entrance to the building is right there. She did make what I would consider to be more than a casual observation. She didn't just glance at it. She actually tested the area before she proceeded. So I think here, Your Honor, there are certainly questions of fact on material issues that need to be resolved by the trier of fact. Given the defendant's duty to inspect, given the slaughter case, the knowledge that they had regarding the precipitation that they argue put my client on notice, certainly would put somebody in a superior position on notice as well. Having said that, Your Honor, again, given the facts of this particular case, the fact that the defendants did not do any inspections, I do think that summary disposition at this time is inappropriate.
So has there been any discovery to suggest what condition the rest of the parking lot was in? Was this simply a solitary icy spot? When I'm thinking about the kind of conditions that are described, if she saw something that appeared to be wet, that would suggest to me that there must have been some kind of precipitation that would have hit the parking lot and frozen.
It was snowing.
And if it happened here, it would have happened somewhere else. It seems like it would have been slippery everywhere. So has that been explored to any witnesses?
Your Honor, it has not, but quite frankly, it'd be an interesting endeavor because there weren't any inspections done for them to report that the parking lot was clean and dry, or we noticed light precipitation at this point in time. I think that given my client's testimony and the condition that she encountered, it's entirely reasonable that anyway she went, she was encountering this obstacle. And under the law, that certainly is a special aspect, clearly in line with the slaughter and other cases cited.
So if I remember correctly, after she tested the immediate portion of the parking lot, she went a few steps and fell.
Correct.
She got up and then she fell again?
That is correct, Your Honor, yes. And then I believe the security, I'm sorry.
So when she fell the second time, was she on her way back into the building or was she continuing on towards her car?
she was going to go back into the building, Your Honor, because once she was on the ground, the area towards her car looked the same as where she was and caused her to fall. And so she was going to go back in. That was the closest place, first of all, to get help. And secondly, she was going to report it, which she ultimately did.
She was in the same parking lot just a few feet away.
Right, but I was just trying to get an idea. So if she turned around and went back after falling, it would mean that she ended up falling on a place that she had already safely traversed until she got to the place where she did fall.
Yeah. If I may, Your Honor, no, I believe that when she tried to lift herself up and get off of the ground, that's when she started flailing again. So she, in essence, fell twice in the same spot.
I got you.
I would disagree factually. I mean, the testimony reads what it was. She got up and turned around and walking back to where she had stepped off the curb. But one other.
Well, where did she fall the second time then? If she didn't fall in the same spot.
No, it was a few feet away. And like the court mentioned, as on her way back to the curb that she had just stepped off of, she went the exact same route back to the door that she just had walked. So the judge was in fact correct. The court.
Well, again, so that goes back to the question I asked. If in fact,
I can
this was an area that she had safely traversed and apparently didn't find to be slippery, and yet on her return path, she actually fell on something that she had earlier safely traversed.
And I think we may be splitting hairs here, Judge, because if you fall down and you get up and you take one step and fall, in my mind, you're in the same spot. I don't know how far away you have to get from that.
Let's look at her actual testimony. Where will I find that?
Page 9 of my deposition, or excuse me, my motion. I quote her testimony.
Oh, okay.
One other point that if the court doesn't mind, Ms. Showerman testified that this particular parking lot, the G lot, was repaved roughly 6 months prior. So the plaintiff hadn't set forth any evidence other than what he just stated on the record that other areas of the parking lot would be just as slippery or just as icy. So I would urge the court, there's been no evidence. I haven't heard, plaintiff hasn't requested depositions, they haven't requested discovery. They haven't set forth anything that to overcome my motion other than the argument on the record. But Ms. Showerman's point was that they had repaved this specific lot 6 months prior in July, I believe. So for, the court can take that for what it's worth, that this was a newly paved lot versus the other lot, and of course the sidewalk.
What difference does that make?
For whatever it's worth, I don't know if a newly paved lot would, I'd be speculating.
All right, I'm looking at her testimony. Give me a second.
And it's also attached as Exhibit A as well.
Yeah, I'm
Sure.
seeing the part where she fell the first time. I'm having trouble finding where she testified to falling the second time. So maybe you didn't quote that. So let me look at her.
Yeah, it's on page 48 and 49 under Exhibit A. That covers that area, that topic.
All right, let me get there.
Page 49.
All right, I've had a chance to review that. So I did note that she testified that once she did fall, she realized that the entire lot was icy. That it wasn't just this little spot she fell on. Basically, it was clear to her at that point that what looked like wet was in fact ice, and this entire parking lot that she was trying to cross was icy. Did I get that right?
That's accurate. Yes.
Accurate, Your Honor, yes.
And there's not been any independent testimony of anyone else who encountered a slick parking lot that morning. No safety reports other than relating to her fall. No maintenance reports showing other than subsequent remedial measures that when this first came to the attention of the custodial staff or whoever it is in charge of spreading salt.
That's correct, Your Honor. Other than that, we're aware of, other than obviously the ambient conditions that defendants were certainly aware of, and plaintiff was aware of as well. So.
Okay, anything further, Mr. Harsha?
No, Your Honor, thank you.
And Mr. Rasher?
No, Your Honor.
Well, it's clear to me that the Supreme Court has taken a pretty strict view, looking at all the cases that Mr. Rasher has cited, as to when a circumstance with black ice is considered not to be open and obvious. Here's a situation where she sees the potential that it could be slippery. In fact, embarks across the lot, finds that it is in fact slippery, and then turns around and returns. I guess in my own mind, if that lot was slippery, why would anyone expect the parking lot or the sidewalk itself not to be slippery? I mean, it seems like whatever condition could have created, uh, uh, whatever weather conditions could have created a slippery parking lot, seems it would also have had to create other slippery surfaces. You know, logically, it just makes sense. I know when we get a freezing rain, it's widespread. You know that it's widespread. What realistic choice does an individual have at that point, other than, I guess, to decide not to go to their vehicle?
Well, Your Honor, she walked on the sidewalk from the building to the parking lot without any issues. It wasn't until she got to the parking lot when she noticed this potential hazard. So we know that the sidewalks were clear.
But do we know why? Do they have heated sidewalks in that area? Do they regularly spread salt on sidewalks but don't spread it in the parking lot? I'm trying to figure out how we would have a situation like this where this entire lot appears to be slippery and nothing else is. Has that been explored?
To be honest, it hasn't. And that, I mean, I think with all due respect to Mr. Harshaw, I believe that favors summary disposition, to be quite honest.
Is discovery complete?
Yes. Discovery is closed.
Well, given the significant number of cases that show, and let me look specifically. I had this spot marked, but I think I've messed up my.
I think Exhibit D, the Jansen case, is.
Yeah, well, I had a segment of the brief, and I closed it. I had it open to that right page. So looking at the precedent that you cited, looks like it starts with the Slaughter decision, and then following that, the Jansen decision, where the court reversed the judgment of the Court of Appeals in lieu of granting leave to appeal and reinstated. Essentially criticizing the Court of Appeals for failing to adhere to the governing precedent that renders alleged black ice conditions open and obvious when there are indicia of potentially hazardous conditions, the specific weather conditions present at the time of the plaintiff's fall. Here, we certainly had indicia of potentially hazardous condition. We saw what she described as wet, which clearly was the shininess that she was seeing, given the temperatures that existed. They weren't wet. What she was seeing was ice. We had temperatures that were well below freezing. I think the record shows it was 21 degrees at the time she fell, and there was light snow falling. These are obvious wintry conditions. These are conditions that would have reasonably alerted an average user of ordinary intelligence to discover the potential danger. She actually seemed to recognize that and unfortunately fell. But I think in light of this precedent, I'm obliged to find that the particular hazard she encountered that day of the black ice was indeed open and obvious within the language of Slaughter and his progeny. So on the issue of open and obvious, I don't think I have any choice but to grant summary disposition to the defendant. With respect to whether it was avoidable, I've got two different routes that are spelled out that show there's other ways she could have gotten to her car other than crossing what appeared to her to be a wet surface. So on that grounds as well, I'm going to grant summary disposition. Mr. Rashard, you'll submit an order consistent with my ruling today.
Thank you, Your Honor.
Great. Thank you very much.
Thank you, gentlemen. Have a good day.
All right. You as well.
Okay, looks like we have everybody here on Bournemouth versus City of Jackson. Mr. Bournemouth is present representing himself. And let's see, Ms. Forbush.
Yes, Your Honor.
And you represent the defendant, and Mr. Hagerty, you're the city attorney, correct?
Yes, Your Honor. Good afternoon. Nice to see you again.
All right, and it appears we also have present the mayor, Mr. Dobies. So I've read everything that you filed. Ms. Forbush, go ahead with your argument.
Keeping in mind, Your Honor, that I know you've read everything, I'll try not to belabor the points, but this is our motion for summary disposition. Plaintiff has alleged a religious discrimination claim, and as this court directed our attention to file supplemental briefs, we did so, and we certainly have in the position, Your Honor, that a city council member pursuant to the economic reality test is not an employee under the Elliott Larson Civil Rights Act. We've set forth the legal support for that, the economic realities, 4 factors. We do not believe that when you look at the totality of the circumstances that a logical holding under ELCRA is that a city council member is not an employee as defined by the economic realities test. Plaintiff tries to distinguish between the fact that he was trying to be appointed to the position as opposed to be elected. I think that's irrelevant. It doesn't change the position itself, and he does not meet the definition of an employee based on the case law. Alternatively, of course, we've argued that Mr. Bournemouth has failed to set forth a viable claim of religious discrimination under ELCRA. It's interesting in this case because of who Mr. Bournemouth has sued, which originally he sued Ms. Robinson and Ms. Schlechte, and then after taking their depositions, after receiving our motion for summary disposition, he dismissed both of those individuals with prejudice. The only defendant remaining, along with the city, is Mayor Dobies, and plaintiff never sued the other 3 council members, Mr. Alexander, Mr. Horvath, or his name escapes me, I'm sorry, Mr. Dancy. And no one nominated Mr. Bournemouth, so Mr. Dobies didn't have an opportunity to vote for him. The next analysis would be, well, these individuals voted for Karen Bunnell because she was Christian. Well, the majority of the council didn't even know that Ms. Bunnell was Christian. and therefore that claim is a bit nonsensical as well. Plaintiff can't point to any evidence to support his claim of discrimination. He takes issue with some things that Mayor Dobies has said in the past, but Mayor Dobies articulated in his deposition that he was looking for someone with the proper temperament, somebody who presented professionally with good temperament to serve as a city council member. Mr. Bournemouth wasn't nominated. He applied, but he wasn't nominated. Therefore, Mr. Dobies didn't have the opportunity to even vote for him. Interestingly, Ms. Schlechte said, geez, I was considering Mr. Bournemouth until he wrote this very negative letter toward me and tried to bully me. When questioned about it in his interview, Mr. Bournemouth admits, yeah, I raised my voice. Yes, I yelled. Yes, I referred to, Mayor Dobies by certain names. He's long held that Mayor Dobies is a liar, that he has no integrity, that he has no respect for him. And yet he blames Mr. Dobies for not getting elected to, or getting appointed to the position when in fact no one on the city council nominated him. The members that Mr. Bournemouth chose to depose clearly testified with regard to their legitimate non-discriminatory reasons for voting the way that they did. And plaintiff has done nothing to show that that testimony is pretextual. All of his allegations are based purely on subjective speculation, Your Honor, and that's simply not enough to withstand a motion for summary disposition on a religious discrimination claim. The other claims that Mr. Bournemouth has, one was for the intentional infliction of emotional distress claim. He didn't even bother to address that in his response to our motion for summary disposition. He did try to bring it up, and I believe improperly so, when the court asked for supplemental briefing on the issue of whether or not a city council member is an employee. Regardless of the fact, he fails to establish extreme and outrageous conduct that goes beyond the bounds of human decency. And his failure to respond to those arguments should deem the matter as waived. He also has failed to address the governmental immunity argument that was made with respect to his remaining counts with regard to ordinance violations. Number one, Mayor Dobies is entitled to absolute immunity from those claims via statute, MCL 691.1407, and plaintiff has failed to establish any exception to governmental immunity for those claims. And as we all know, the exceptions to governmental immunity are very narrowly construed. They are confined to very specific statutory exceptions, and plaintiff hasn't addressed the governmental immunity aspect of his claims. As a result, summary disposition is warranted in this instance on all claims. If the court has any questions, I'd be happy to address those.
I do not. Mr. Bournemouth?
Yes, Your Honor. First, addressing the economic realities test and the idea whether or not a council member is an employee. I think it's clear from the four parts that the council member's behavior and work is controlled by the city. They are paid a salary by the city. In this case, the council member was hired by the city. And finally, the city charter clearly gives council responsibility for maintenance of discipline. Those are the four parts, and they all exist in this case, Your Honor. So I think clearly that the council members are employees given under Electra. Secondly, I think that discrimination is quite clear on the basis of the evidence submitted by Derek Dobies and the city. I think the real question in this case is the one that counsel for the defense raised, whether or not there is immunity, governmental immunity, either qualified or absolute for the defendants in this case. I don't believe it exists. I acknowledge that I did not do a good job in my brief addressing that, so I'd like to address it now. The defendants cited Payton versus City of Detroit for the proposition that a city, a municipality cannot be held liable for intentional torts of its employees or agents. First, I note that was prosecutorial misconduct that was at question, and prosecutorial immunity is a whole different beast. But secondly, I note that that Payton was in 1995. In 1997, in a case called Sedal versus City of Hamtramck, 221 Mich. App 455, the court held that intentional torts are torts not shielded from the government immunity statute as to governmental employees. And I just propose here that this was an intentional tort by Mayor Dobies. During the questioning at City Council, which each question is normally asked of every single applicant, in this case, Derek Dobies deliberately set out to grind his Christian axe and ask me about my language usage, which is not an issue that was before City Council for my employment or my appointment. And I also claim totally that a person who tells another human being to move the bones of their ancestors because they don't like herbicide being sprayed, poison being sprayed on their grave, is malicious and meets all the standards that are required for intentional infliction of emotional distress. So, Your Honor, I believe that in this case, discrimination is clear based on the evidence I provided, the emails I provided about Derek Dobies and my exchanges. Every issue we've had has been over the question of religion or over the question of speech about religion. And you can see where, Derek Dobies says, oh, Good Friday is a union, negotiated holiday. And I say, well, it's a holiday that's only, believed in by, celebrated by one religion, so it shouldn't be an official holiday. And on and on. Every issue we've had has been over religion. And Mayor Dobies has excluded me time and time again from any appointment or any position on the basis of his prejudice against my pagan religion, which finds that the Christian religion is the single most evil, repressive, and reactionary force in recorded human history. So I think the real question in this case is whether or not the defendants have governmental immunity, both from torts and from my claims for emotional distress. I also point out that case law says a plaintiff may sue a municipality in federal or state court under 42 U.S.C. 1983, and a plaintiff may bring an action against an individual defendant under Section 1983 and common law tort remedies. And that's Alexander versus Rick.
I can't hear him, Your Honor.
I don't think anybody can. We lost your audio, Mr. Bormuth.
Okay. I think there was deliberate discrimination by the defendants. There's a history of discrimination by the defendants, including intimidation, sending police officers to my door. I just feel like there's absolutely no way that Karen Bunnell was remotely as qualified as I was, Your Honor. And so you have to search for a reason. They want to talk about temperament, but my temperament is proven. I've been at city council meetings over and over and over. I've been at other governmental meetings. There's never been an issue with me. I speak my 3-minute piece at the beginning on public comment, and then I sit and listen to everybody else. So my temperament is perfectly suited for government service, actually. And they just don't want me because of my attitude as a pagan toward the Christian religion. So if there are torts available, I should receive them. If they're not, I would like a ruling of discrimination and a nominal damages of $1.
Anything further, Mrs. Forbush?
Yes, just briefly, Your Honor, just to make certain that our arguments are clear. Obviously, governmental immunity does not apply to an Elliott Larson Civil Rights Act claim, and we are not claiming that. In that regard, we claim that a city council member is, one, not an employee, and two, Mr. Bormuth has not met the prima facie burden in that instance. He has not set forth any evidence, direct or indirect, of religious discrimination. He focuses on Mayor Dobies, but again, I suggest to this court, Mayor Dobies is but one man with but one vote. And Mr. Bormuth applied for the position, but was not nominated by a panel of 7 members. With regard to the intentional torts, his reliance on Sudol versus Hamtramck is mistaken. Sudol dealt with whether or not you could transform an intentional tort into a gross negligence action and what immunities would apply to an intentional tort. In this instance, he has a very specific intentional tort claim of intentional infliction of emotional distress, which carries even a higher standard of extreme and outrageous behavior that goes beyond all bounds of human decency. In our brief, we cited to Odom versus Wayne County, but that was on behalf of the 2 city council members, not the mayor, because the mayor under statute, MCL 691.1407, is entitled to immunity from tort liability. Plaintiff also references 42 USC section 1983, which from the Civil Rights Act. He doesn't have a federal claim in this instance, Your Honor, and that's completely irrelevant. I think his language is interesting because he says, well, they haven't appointed me to positions and we have to, quote, search for a reason. Well, we can't have lawsuits based on sheer speculation. There has to be facts and evidence, and he doesn't have any to support his claims.
Thank you. So I first want to address the whether or not. Sorry, Mr. Bormuth.
May I respond to that, Your Honor?
Well, I will allow you. Normally, we have arguments, response, and then an opportunity to respond to that by the moving party. I'll give you one more chance. Go ahead.
Well, I just want to respond to the idea that Derek Doby's vote was only one of 7. It wasn't one of 7. It was one of 6. And if Derek Doby's had not voted for Karen Bunnell, she wouldn't be appointed. So I think that's a key issue contrary to the defendant's argument. And beyond that, obviously government immunity, they admit, doesn't apply to Elliott Larson's Civil Rights Act. All of the emails I submitted between myself and Derek Doby's show deliberate discrimination, Your Honor, on the basis of his Christian religion. So I'm just, I'm done, Your Honor. Thank you.
All right, thank you. So on the issue of whether or not a city council person is an employee, acknowledge I raised the issue as I was reading the motion. Unlike Title VII, which specifically exempts elected officials from the realm of persons protected by Title VII's anti-discrimination provisions, the Elliott Larson Civil Rights Act is silent about whether or not an elected official is within the scope of the persons to be protected by the Elliott Larson Civil Rights Act. Nevertheless, And going beyond that, there really is no definition of employee. So who is an employee correctly is determined under the economic reality test. The one indicia that would suggest that they're employees is the fact that they're paid a salary and taxes are withheld. A W-2 is issued. So at least for purposes of the way in which they are compensated, it's more in line with an employee. But we also have four parts to the economic reality test. So there isn't any argument as to what those are. And forgive me as I lay them out. Yeah, the first factor is control, and it's interesting. Normally, in determining in a number of arenas whether someone is an employee versus an independent contractor, control is by far the most important factor. In this case, there's frankly very little control. There is certainly an ability if a council person acts contrary to law to take steps to address that, but ultimately it's up to either the voters or the governor. The city cannot actually remove a council person. They can start the process for that happening either through a recall or through the government determining that the governor determining the person's no longer qualified. But that's nothing like an employer-employee relationship. An employer doesn't have to go anywhere to get permission to fire an employee. They just do it. Here, the ability to remove a sitting councilman is very narrow and very restrictive. So also in terms of how they do their work. Now, certainly they got to follow the same rules everyone else does under the city charter for how you enact a piece of legislation. They're subject to those kind of rules, but in terms of their day-to-day activities, there's no control. I mean, they have to be there at council meetings in order to have their vote counted. They have to be present, but they don't get penalized if they're not there. There's just very little control. I've already addressed the payment of wages here. They are indeed paid as if they were employees. That would weigh in favor of a finding that they are employees under the economic reality test. But under control and also hiring and firing. There's no hiring and firing. There's appointments to fill a vacancy, but absent a vacancy, hiring is done by the electorate. Firing is done by the electorate when they don't get reelected. The ability to fire a councilman just simply doesn't exist. And finally, responsibility for the maintenance of discipline. If I look at the totality of circumstances around here, I'm hard pressed to say that these councilmen are employees and are within the scope of persons to be protected as employees under the Elliott-Larsen Civil Rights Act. But beyond that, looking at the merits of the claims themselves, first of all, with respect to whether or not the plaintiff's rights under the Elliott-Larsen Civil Rights Act to be free from discrimination in employment, frankly, plaintiff has simply failed to prove his case. The only person here that's ever tried to make religion an issue is Mr. Borma. There's no indication and no evidence that any of the defendants ever tried to make Mr. Borma's religion an issue. There were some concerns about the level of attack that Mr. Bormuth has levied against people of the Christian faith. And I think that's a valid concern. If we had a potential councilman who made a point of branding all Muslims as scum, I would certainly hope that our city council would never appoint someone who did that as a council person. A councilman has to have the trust of his electorate, and granted, there wouldn't be an electorate per se if he's initially appointed, but certainly in order to continue to serve in that, you have to be able to represent everybody that's within your district. I can't imagine even Mr. Bormuth would advocate that someone who refers to people of the Muslim faith as Muslim scum would be qualified to serve in an elected or appointed position within the city. So to the extent there were concerns about Mr. Bormuth's hostility to people of the Christian faith, I think that's a valid concern. But other than that, there's no indication whatsoever that there's been any concern about Mr. Bormuth's personal beliefs or personal faith. There simply just isn't any evidence to support a claim that he was discriminated against based upon his religion. As to the other claims, the intentional infliction of emotional distress, the threshold for meeting that claim is extremely high. It has to be truly outrageous and intolerable in a civilized society. And the only thing that Mr. Bormuth has suggested as to Mr. Doby's that in his mind rises to that level is when the mayor told him if he was concerned about pesticides on his ancestors' graves, that perhaps he should have them moved to another cemetery. I would think if Mr. Doby's had undertaken to remove remains from a grave and have them moved to another location himself, I could definitely find that as outrageous, intolerable in a civilized society. But merely suggesting to Mr. Bormuth that he consider doing that, there's no question of fact. It simply does not rise to the level of what is the minimum required in order to advance a claim for intentional infliction of emotional distress. The remaining claims with respect to violation of various aspects of the city charter, I agree with the defendant. Whether or not those even state claims, they do not allege any avoidance of governmental immunity, and governmental immunity absolutely applies to each one of those claims. So for those reasons, I am dismissing all of Mr. Bormuth's claims. Ms. Forbush, you will present an order to that effect.
I shall, Your Honor. Thank you.
Thank you.
Thank you, Your Honor.
Have a good day, everyone.
You
Thank
too,
you.
Your Honor.